parole, supervised release, and the question of when someone is ready to come home. The prison sentence reads 20 years. The family reads the same sentence differently. How long until parole? For generations, parole represented one of the central ideas of American corrections. People could earn their way back into society through good behavior, rehabilitation, education, work, and demonstrated change. In recent decades, that philosophy has shifted. Some states abolished parole entirely. Others restricted it. Federal courts replaced parole with supervised release. Georgia retained parole but modified its use over time. Today, America operates several overlapping systems designed to answer one difficult question: when has someone served enough time to safely return home? Reasonable people disagree. Victims may answer differently than offenders. Families may answer differently than prosecutors. Communities may answer differently than correctional professionals. The debate sits at the center of modern criminal justice. What is parole? Parole is not forgiveness. Parole is not exoneration. Parole is not the cancellation of a sentence. Parole is conditional release from incarceration before the completion of a prison term. The sentence continues. The supervision continues. The rules continue. The location changes. Instead of a prison cell, the person serves the remainder of the sentence in the community under conditions established by parole authorities. Violation of those conditions may result in a return to custody. The original theory of parole. The modern parole movement emerged during the 19th century with a simple belief: human beings can change. If rehabilitation matters, then correctional systems should reward effort and progress. Education, vocational training, treatment participation, disciplinary records, work performance, institutional behavior. Parole created incentives for improvement, while providing correctional systems with tools to manage prison populations and encourage rehabilitation. The philosophy reflected optimism about human potential. The tough-on-crime era, beginning in the 1970s and accelerating through the 1980s and 1990s, many states reconsidered parole. Critics argued that parole created uncertainty. Victims did not know how long offenders would actually serve. Sentences announced in court often differed dramatically from time actually served. Public confidence suffered. Many jurisdictions moved toward determinate sentencing systems that reduced or eliminated parole discretion. The federal system abolished traditional parole for offenses committed after 1987 and replaced it with supervised release administered after completion of imprisonment. The philosophy shifted from rehabilitation toward certainty and accountability. Georgia's system. Georgia remains a parole state. The Georgia State Board of Pardons and Paroles holds constitutional authority over parole decisions, pardons, commutations, and restoration of rights. Georgia uses parole decision guidelines that consider the severity of the offense, criminal history, institutional behavior, risk assessments, likelihood of reoffending. These guidelines generate recommendations but do not bind the board absolutely. Final authority remains with the board itself. Parole eligibility is not the same thing as parole entitlement. Eligibility opens the door. It does not guarantee release. Hall County as a local lens. For residents of Hall County returning from state incarceration, parole decisions often determine when reintegration begins. The transition affects employers, families, churches, probation officers, treatment providers, and housing programs throughout Northeast Georgia. A parole release is not simply an event occurring inside a prison. It becomes a community event. The community ultimately becomes the place where success or failure unfolds. The parole hearing that never happens. Many Americans imagine parole as dramatic hearings resembling courtroom trials. Victims speak. Families speak. Attorneys argue. Board members deliberate. That sometimes occurs. More often, parole decisions involve records reviews, institutional files, recommendations, victim input, and guideline calculations rather than lengthy public hearings. The reality is administrative rather than theatrical. The consequences remain enormous. The victim's perspective. Victims and survivors often experience parole reviews differently than correctional officials do. For some victims, parole hearings reopen wounds that never fully healed. Some strongly oppose release. Others support it. Some choose not to participate at all. Modern parole systems increasingly emphasize victim notification and participation rights. Georgia's parole system explicitly recognizes victim rights as an important component of decision-making. No single victim perspective exists. The emotional realities vary enormously. The family waiting at home parole decisions affect entire families. Children grow up counting years differently. Birthdays, graduations, holidays, parents age, relationships evolve. The parole date becomes more than an administrative milestone. It becomes a calendar around which lives are organized. For families, parole is often measured not in months served, but in moments missed. Supervised release, the federal alternative. Federal criminal justice moved in a different direction. Instead of traditional parole, federal courts generally impose terms of supervised release following incarceration. The individual serves the prison sentence first. Supervision begins afterward. Conditions may include reporting requirements, drug testing, employment obligations, travel restrictions, treatment participation, financial disclosures, geographic limitations. Violations may result in additional imprisonment imposed by the court. The philosophy differs from parole. Parole shortens prison time. Supervised release follows prison time. The technical violation problem. One of the most significant challenges in both parole and supervised release involves technical violations. Not new crimes. Not violence. Technical violations. Missed appointments. Positive drug tests. Missed treatment sessions. Unauthorized travel. Failure to report address changes. Across the United States, supervision violations continue to drive a substantial share of prison admissions. In 2023 alone, nearly 200,000 prison admissions nationally resulted from probation or parole violations, including more than 110,000 for technical violations rather than new criminal convictions. This statistic has become central to modern reform discussions. The public safety argument. Supporters of strict supervision policies make an important point. Conditions exist for reasons. Victims deserve protection. Courts deserve compliance. Communities deserve safety. If supervision conditions carry no consequences, supervision itself loses credibility. Accountability matters. Public trust matters. These concerns are legitimate. The reform argument. Critics respond with a different concern. Not all violations are equal. A missed counseling appointment differs from armed robbery. A failed drug test differs from assault. A missed curfew differs from domestic violence. Many reformers argue that technical violations should trigger graduated sanctions rather than immediate incarceration whenever public safety permits. The goal is proportionality rather than leniency. The mathematics of recidivism. Parole boards and supervision officers operate under enormous pressure. Release someone who later commits a serious crime and headlines follow. Deny release to someone who would have succeeded quietly, and few people notice. This asymmetry influences decision-making. National research consistently shows substantial rates of rearrest following release, particularly during the first several years after release. Studies of state prisoners released in 2005 found that approximately 68% were rearrested within 3 years and 83% within 9 years. Those numbers are important. They are not destiny. Most rearrests are not violent crimes. Many people never return to prison. Context matters. The Georgia debate. Georgia continues to debate the proper role of parole. Some reform advocates argue that parole opportunities encourage rehabilitation and reduce prison costs. Others argue that violent offenders should serve substantially more of their imposed sentences. Recent analysis suggests that many Georgia prisoners complete their full sentences without parole release, reflecting a system that has become considerably more restrictive than earlier generations often assume. The political and moral debate remains active. Can people change? Every parole decision ultimately rests upon one philosophical question: can people change? If the answer is no, parole becomes difficult to justify. If the answer is yes, permanent incarceration becomes more difficult to defend. Most criminal justice systems implicitly accept both ideas simultaneously. Some people remain dangerous. Some people do not. The challenge lies in distinguishing between them. No algorithm solves that problem completely. No parole board solves it perfectly. The weight of prediction. Parole boards do not decide the past. The conviction already did that. Parole boards attempt something much harder. They attempt to predict the future. Will this person succeed? Will this person relapse? Will this person hurt someone? Will this person become a taxpayer, parent, employee, volunteer, mentor, or business owner? The future remains stubbornly difficult to forecast. The meaning of time served. The phrase appears simple, time served. But what does it mean? The court imposed punishment. The prison delivered punishment. The offender completed programs. Victims endured loss. Families endured absence. Communities absorbed costs. At what point has justice been satisfied? Every society answers differently. America continues debating the answer. The door opens again. Eventually, the gate opens. The paperwork is signed. The ride home arrives. The community takes over where the correctional system ends. The parole officer becomes more important than the prison guard. The employer becomes more important than the prosecutor. The landlord becomes more important than the judge. The next chapter examines perhaps the most powerful force in determining what happens next. Family, community, churches, mentors, and the social networks that often decide whether re-entry succeeds or fails, long before government programs have a chance to help. Chapter 23: Family, Community, Faith, and the people who catch you when you fall. The prison gate opens. The parole paperwork is signed. The probation officer schedules the first appointment. The criminal justice system has completed its part. Now another question begins. Who is waiting outside? A mother with a spare bedroom. A brother willing to offer work. A pastor with a support group. A mentor willing to answer late-night phone calls. A recovery sponsor. A neighbor, a friend, or no one at all? The answer to that question may predict re-entry success more accurately than almost anything found in a court file. Criminal justice professionals often speak about risk factors. Formerly incarcerated people often speak about people. The difference matters. The invisible infrastructure. Every successful community has infrastructure. Roads, power lines, water systems, schools, hospitals. Less visible, but equally important, are social systems, families, churches, mentors, neighborhood organizations, employers willing to hire, volunteers willing to help, Community support networks often determine whether a person survives the transition from incarceration to stability. Researchers increasingly describe these networks as forms of social capital, relationships that create opportunity, accountability, and belonging. Family support and recidivism. The research on family support is remarkably consistent. People leaving incarceration who maintain strong family relationships generally experience better employment outcomes, better mental health outcomes, more stable housing, lower rates of reoffending. This does not mean families solve every problem. Some families are unsafe. Some relationships are damaged beyond repair. Some households struggle financially themselves. But where healthy family support exists, it often becomes one of the strongest protective factors against recidivism. The family that stayed. Families often serve sentences too. Parents drive hundreds of miles for visitation. Spouses manage finances alone. Grandparents raise children. Brothers and sisters explain absences to neighbors and schools. Children grow older during incarceration. The public often measures incarceration in years served. Families often measure it in birthdays missed. The release date does not erase those years. Relationships require rebuilding. Trust requires rebuilding. Routine requires rebuilding. Re-entry is rarely an individual process. It is usually a family process. Hall County as a local lens. Hall County provides examples of how community organizations attempt to fill gaps that government alone cannot address. Programs connected with the Hall County Correctional Institute's REACT Transition Program emphasize employment, responsibility, and structured reintegration before release. Participants work, contribute toward living expenses, and begin rebuilding ordinary routines before returning fully to the community. Community organizations such as the United Way of Hall County help connect local residents with housing, stability, and social services that often become essential during periods of transition. These organizations rarely appear in sentencing hearings. Their impact may be greater than many sentences. The mentor. Many formerly incarcerated individuals describe one turning point. Not a court order, not a probation condition. A person. Someone who answered the phone. Someone who expected accountability. Someone who believed change was possible. Mentorship programs have increasingly become part of re-entry strategy nationwide because trusted relationships often succeed where formal supervision alone struggles. Human beings change in relationship with other human beings. Technology can help. Programs can help. Policies can help. Relationships remain central. Faith communities. Faith communities have played an important role in American re-entry efforts for generations. Churches, mosques, synagogues, temples, faith-based recovery groups, volunteer ministries, prison visitation programs. Supporters argue these organizations provide belonging, accountability, practical assistance, transportation, clothing, housing support, employment connections, hope. Critics caution that public services should remain available regardless of religious affiliation and that participation should remain voluntary. Both principles are widely accepted. The practical reality is that faith communities remain among the largest volunteer providers of re-entry support in America. Gainesville and Hall County examples. Faith-based organizations throughout Hall County participate in mentoring, counseling, education, and community support efforts. Programs associated with local ministries and community outreach organizations provide mentoring opportunities, counseling support, and educational services to vulnerable populations across the county. These services may not carry the title criminal justice reform. Their effects often influence criminal justice outcomes anyway. Housing as community researchers continue reaching a similar conclusion. Housing stability matters. perhaps more than almost anything else. Individuals who lack stable housing experience substantially greater risks of recidivism and supervision failure. The effect appears particularly strong among lower-risk offenders who might otherwise succeed with minimal intervention. Housing is more than shelter. Housing is an address for employment applications, a place for medication, a place for children to visit, a place to receive mail, a place to sleep without fear. Stability begins with a key. The employer as community partner. Employers often see themselves as businesses rather than social institutions. In practice, employers frequently become some of the most important participants in re-entry. Employment creates income, structure, routine, social relationships, self-respect. The evidence connecting employment and successful re-entry remains strong, although research suggests employment alone is rarely sufficient without housing and community support. The paycheck matters. The purpose often matters more. The limits of government programs matter. Probation matters. Treatment matters. Housing assistance matters. But government rarely substitutes fully for community. A probation officer supervises. A mentor encourages. A social worker coordinates. A family member answers the phone at midnight. These roles overlap. They are not identical. Successful reintegration usually requires several of them operating together. The social isolation problem. One of incarceration's least visible effects is social isolation. Friendships disappear. Professional networks disappear. Community ties weaken. Technology changes. Neighborhoods change. Formerly incarcerated individuals often describe the experience as returning home while simultaneously feeling like strangers in familiar places. Isolation itself becomes a risk factor. Connection becomes part of treatment. What research actually shows, popular political discussions often focus almost exclusively on punishment severity. Research increasingly focuses elsewhere. Housing, employment, health, mentorship, family support, community integration. The emerging evidence suggests that successful re-entry depends less on any single intervention and more on combinations of support operating together. The problem is complex. The solutions appear equally complex. The neighbor question. Every community eventually faces a practical question. What happens when someone returns home after incarceration? Will the neighborhood reject them, ignore them, employ them, mentor them, fear them, welcome them? There is no universal answer. Communities respond differently. Individuals respond differently. The question remains unavoidable because almost everyone incarcerated eventually comes home. The community will meet them eventually. The only question is under what conditions. Accountability and grace. The words are often treated as opposites. They are not. Accountability asks, what happened? Grace asks, what happens next? Communities need both. Victims deserve accountability. Returning citizens require opportunity. Public safety often depends upon balancing the two. Too much of one without the other tends to fail. The person waiting outside the gate. The justice system measures risk scores. Families measure phone calls answered. Researchers measure recidivism. Communities measure neighbors restored. Every release eventually arrives at the same moment. The gate opens. The individual walks out. Someone is standing there, or no one is. That difference may matter more than almost anything that happened inside the courtroom. The next chapter examines the role of victims, survivors, and restorative justice movements that seek not only punishment, but healing, accountability, and repair, where repair remains possible. Chapter 24: Victims, Survivors, and Restorative Justice. The criminal case begins with a crime. The police report records the facts. The prosecutor files charges. The defense attorney prepares a defense. The judge schedules hearings. The defendant becomes the center of the legal process. Sometimes another person disappears from view. The victim, the survivor, the family left behind. For much of modern criminal justice history, victims occupied an unusual position. The crime happened to them. The state prosecuted it. The lawyers argued about it. The courts resolved it. Yet many victims described feeling more like witnesses to the process than participants in it. This chapter asks a difficult question. What does justice mean to the people who were harmed? The answer is often more complicated than punishment alone. The rise of victims' rights. For much of American legal history, criminal prosecutions were understood primarily as disputes between the government and the accused. Victims provided testimony. The state pursued the case. The victim often had little control over whether charges were filed, dismissed, negotiated, or resolved. Beginning in the late 20th century, victims' rights movements sought to change that reality. Today, every state provides victims with some combination of rights involving notification of hearings, participation in proceedings, impact statements, restitution, protection from intimidation, information about release decisions. The modern justice system increasingly recognizes that crimes create victims as well as defendants. Georgia's Crime Victims Bill of Rights. Georgia law provides extensive protections for victims and survivors through the state's Crime Victims Bill of Rights. Victims may be entitled to notice of proceedings, information regarding release or escape of offenders, opportunities to provide impact statements, and assistance navigating the criminal justice process. These rights do not determine guilt or innocence. They ensure participation. That distinction matters. The justice system belongs to the public. Victims are part of that public. Hall County as a local lens. Hall County maintains dedicated victim support services through its Victim Assistance Program and Victim Witness Assistance Program. These programs assist victims with court information, safety planning, compensation applications, referrals to counseling, victim impact statements, protective order information, crisis support. The programs exist because navigating criminal proceedings can be overwhelming even under the best circumstances. For many victims, understanding the system becomes almost as difficult as surviving the crime itself. The limits of punishment. Victims do not all want the same thing. Some want incarceration. Some want restitution. Some want treatment for the offender. Some want explanations. Some want apologies. Some want safety. Some simply want the event to stop defining their lives. Research repeatedly shows that victims often seek information, accountability, acknowledgement of harm, and opportunities to be heard in addition to traditional punishment. The criminal justice system is designed to deliver verdicts. Human beings often seek something larger. Global Robotics Corporation Wizard.